Most clinic owners have heard the term CPOM, but here's the truth. Very few actually understand what it means. And that's dangerous because the corporate practice of medicine, or CPOM, isn't just another compliance acronym. It's one of the most important legal doctrines in healthcare. And if you structure your business the wrong way, you could be operating illegally without even knowing it. In this video, I'm going to explain exactly what CPOM is, how different states enforce it, and the right way to use the PC-MSO model so your clinic can grow safely and sustainably. Hi, I'm Dr. Christopher Seitz, Chief Medical Officer at GuardianMD. I work with nurse practitioners, Medspa owners, IV therapy entrepreneurs, and healthcare leaders all over the country to make sure that their businesses are structured correctly, compliant with state laws, and built to last. So let's start with the basics. CPOM stands for Corporate Practice of Medicine. It's a legal doctrine that prevents corporations and business people from practicing medicine or controlling the way physicians treat patients. In simple terms, CPOM makes sure medical decisions are made by doctors, not CEOs, investors, or business executives. Why does this matter? Imagine a large corporation opening a chain of clinics and pressuring doctors to prescribe certain medications because of the financial deal with a drug company. Or imagine a CEO telling physicians to see more patients in less time, cut corners on chart reviews, or deny more expensive treatments just to save money. In all of these cases, patient safety takes a back seat to profit. CPOM exists to prevent that. At its core, the doctrine ensures that medical judgment stays with licensed providers, that patients' best interests come before profit margins, and that physicians remain accountable for quality and safety. Now here's where it gets tricky. CPOM isn't enforced the same way in every state. In strict states like California, New York, Texas, and North Carolina, non-physician ownership is prohibited, and regulators closely monitor how management companies interact with medical practices. Other states take a moderate approach, with some carve-outs for nurse practitioners or certain practice types. And then there are the more permissive states like Florida, which don't have formal CPOM restrictions, but still regulate things like fee splitting and fraud. Think of it like driving on a highway. Some states have police cars everywhere enforcing the rules, while others don't. But whether you see an officer or not, the laws still apply. So how do clinics operate legally under CPOM rules? That's where the PC-MSO model comes in. The PC, or professional corporation, is the physician-owned entity and makes all the medical decisions. The MSO, or Management Services Organization, is non-physician owned and runs the business side, things like payroll, marketing, scheduling, and HR. Together, they sign what's called a management service agreement, which spells out services and fees. This model works because it separates the roles. The PC is like the pilot flying the plane, and the MSO is like the ground crew making sure the plane has fuel, luggage, and a flight path. Both are essential, but only the pilot can fly. The result is that physicians stay focused on patients, while entrepreneurs and investors can scale the business without crossing into medical decision-making. Unfortunately, some clinics try to cut corners with what's called a straw man arrangement. That's when a physician is technically listed as the owner, but in reality has no control or involvement, while the MSO makes all the decisions. Regulators, especially in states like North Carolina, have explicitly warned against this. If all patient money flows directly to the MSO, if the MSO hires and fires providers without physician input, or if the doctor isn't reviewing charts or signing off on protocols, you've got a straw man, and that's illegal. In a compliant setup, patient revenue always flows into the physician-owned PC first. The PC then pays the MSO under the terms of the management service agreement. The MSO charges either a fixed fee or a cost-plus model, both of which are considered safe. Percentage-based fees are riskier, and in some states like New York, they're flat-out prohibited. California may allow them if they're commercially reasonable, but most operators avoid them to stay on the safe side. Let's look at a few examples. In California, CPOM rules are strict, but percentage-based MSO fees may be allowed if they meet commercial reasonableness and standards. In New York, the rules are even stricter. Percentage-based fees are banned completely, and only fixed or cost-plus models are allowed. In Texas, non-physician ownership is prohibited outright, and regulators have penalized businesses where MSOs had too much control. In North Carolina, the board warns specifically against straw man structures. And in Florida, while there's no formal CPOM law, they can still get in trouble for fee splitting or sloppy structures. Now, you might be thinking, if my state doesn't enforce CPOM, do I really need to worry about all of this? The answer is yes, and here's why. Even in permissive states, clinics benefit from using the PC MSO model. First, it makes scaling across state lines easier. If you start with a simple LLC in Florida, but later want to expand to California or Texas, you'll have to rebuild everything. If you start with the PC MSO from day one, your model works everywhere. Second, it builds exit value. Investors and private equity buyers prefer to acquire MSOs because they can scale them nationwide, while physician-owned PCs are harder to sell. And third, it future-proofs your business. Healthcare laws almost never get looser. By adopting a compliance structure early, you won't have to scramble if regulations tighten later. So what happens if you ignore CPOM or fee-splitting laws? The consequences can be severe. State boards can discipline providers, suspend licenses, impose civil fines, or even invalidate your contracts. In some cases, there can even be criminal penalties. And the damage to your reputation and business value can last far beyond the initial penalty. At the end of the day, the corporate practice of medicine isn't just a legal technicality. It's a safeguard that keeps medical judgment in the hands of licensed providers and keeps patient safety above profit. For clinic owners, med spas, and healthcare entrepreneurs, a compliant PC MSO model isn't just about avoiding penalties. It's the foundation for building a scalable, investor-ready business that can thrive in the long term. I'm Dr. Christopher Seitz. If you found this video helpful, please hit the like button, subscribe for more compliance and clinic growth strategies, and leave your questions in the comments. And for more resources on CPOM, medical oversight, and healthcare compliance, visit GuardianMD.com. Thanks for watching. I'll see you next video.